Morning, class.
Good morning, sir.
Hello.
Sir.
Morning, sir.
Morning, sir.
Morning,
Good
Morning,
class.
sir.
Morning, sir.
Good morning, sir.
Hello, can you hear me, please?
Yes, sir.
Yes,
Yes,
sir.
we can hear you.
Yes, sir.
Good morning and welcome to today's class. Coordinator, you are raising your hand. What can we do
Yes,
for
sir.
you?
Good morning, sir. You said I should remind you that you have someone's question to take.
You said what?
You said I should remind you that you have someone's question to take at the beginning of this class.
Okay, I can't remember the question. So if the question is on the platform, then let us know and then we can take it off from there. Meanwhile, while the person is getting ready, can we know where we stopped in our last class so as to guide our discussion for this morning?
Okay, sir. Good morning, sir.
Sources of Sharia.
Good
Good morning,
morning.
sir.
Yes.
Yes, sir. For our last class, we did Islamic laws.
Okay.
So, you explained that this refers to the religious law based on Islamic faith and is applicable to members of the faith. You also said the Islamic law is not a customary law, but it was introduced as part of the constitution. So you also moved to the characteristics of the Islamic law, which you said is largely written. You also said it's rigid. It's a divine law. It's a uniformity of laws and not derived from customs, because because the law is a divine law. So then you also explained the sources of the Islamic law.
All
When
right.
you explain sources
Thank
of
you.
Islamic law, sir?
Yeah, go ahead.
Okay. You said when you explain the source of Islamic law, you said it was from the Quran.
You can go
You
ahead.
Sir? You mentioned the Quran, then you said Idati or Sunnah.
Hello.
Hello, sir. Hello, sir. I can hear you, sir. So when you talked about the sources of the Islamic law, you mentioned the Quran as number one. Then moving on, you mentioned Idat, you mentioned the Ijma and the Qiyas. And explaining those when you explain them, you explain the Quran. It is the secret book of the Islam religion. Then when you explain the Idat, you said you said they mean is a way or rule or mode of life. You explained then you mentioned the three kinds of Idat, which you said was Siyat, Azan, and Dafi. I can't really pronounce them correctly, sir. But you also explained the Ijma, which means is to had. Then you explain the kind of people, um the, about the Qiyas. you said the chaos means to weigh or measure. It says the process of deduction by which the law of text is applied to cases which though not covered by the language or text of govern. Then moving on, you explain the original order in which the text, or you explain the original order of the under the chaos. You explain the original order, you explain the results, you explain the chaos should be a certain law and not determined by means of words. Then that's where we stopped when you explained the chaos, and when we also talked about some other things that where we also gave them some arguments and for some questions about why the Islamic law is imputed in the constitution when it's not actually a customary law. Then moving on, you said the next class we're going to talk on international law.
So excuse me.
Yes.
I think he got locked out too. I don't think he can hear what you're saying. Thank you.
Are you serious? So like I'm talking.
Yes.
Oh, that was nice. That was nice. Any comes
Thank
on
you.
again? Continue, no problem.
Sorry, fine boy, the boy that just spoke, please send your notes to the group chat. If you have notes, please send. Thank you.
You know, actually, I kind of didn't take
Sorry,
notes.
bro. Sorry.
Can you
You
open
didn't
the
take notes and you
back?
knew all that.
What do you say?
Hey, I said you didn't take notes and you know all of this.
Not really a note, like I just jotted. I didn't have
Eh,
notes.
please,
Whatever
send
you
your
wrote
things, whatever
down,
you
my
have,
send
just
network.
send it to the
it.
group.
Just
There's
send
no
it.
way
Whether it's notes, whether it's jotings,
Okay.
just send it.
All
Now
right.
the
So
thing is, who's going to leave the class for the lecturer to come in now?
It's in already. It's in already.
All right, thank God though. Did you hear me? Jesus.
Okay, sir.
please, can you mute your mic? The network is kind of terrible. Can you hear me?
Yes, sir.
Yes,
Yes,
sir.
we can
Yes, we
hear
can
you.
hear you, sir.
All right. So, not sugar. Have you been able to identify who the person is?
Not yet, sir.
Okay,
The
I
person
think.
hasn't come forward.
Okay, so I think we can go into the business of the day then. All right, so we have been looking at sources of Nigerian law for some time now. And so far, we have looked at Nigerian legislation as number one of it. We have also looked at the received English law as one of the sources of Nigerian law. We also look at case law as another source. Then we took on customary law as another one. And we looked at Islamic law in our last class as one of the sources of the Nigerian law. So today we are going to look at the fifth or the sixth one, which we have tagged international law. But before I will start, is there anyone on the platform who can speak to us briefly on why international law should be part of the sources of Nigerian law? Can anybody speak to us briefly on that? Yes, Adewale, Adeyemi, go ahead.
Yes. Okay. So the reason why international law should be a source of Nigerian law is because Nigeria is part of many international organizations like the United Nations and the African Union. And within those international organizations, a lot of times resolutions might be made for specific things for the member nations to do, which might mean that a lot of the time that member nations might need to create or modify laws within their own country. which is why sometimes sources of Nigerian law can sometimes be international law.
But what do we need international law for in our system as an independent nation?
Well,
I'm speaking to, is it Adewale that is still talking?
yes, as me.
Yes, I'm engaging you based on your question. So let's talk. Go ahead.
As in, you're asking what we need international law for. Well,
Why
I think
should
we
it
need,
be?
why should it be? Well,
More,
because,
more so that we are a sovereign nation.
well, it is true that we are a sovereign nation, but every nation has allies. And you can, even as a sovereign nation, you cannot really be, unless you are all powerful. And even the most all powerful of nations might still need to cooperate with other nations, which means that you might have to make deals with other nations and you might just have to, for the purposes of your alliances and for the purposes of your nation's interests, it might just be best to sometimes take the resolutions made from outside the country and decide that we're going to apply it to within the country.
All right. Okay. Okay. I've taken your response and I'm holding on to it. I will refer to it in the course of the lecture. Divine or Generobo. Can we have you? You're raising your hand. Or Joy. Is Joy is it Adeleke now? Adeneko or Adeleke?
Good morning, sir.
Yeah, good
So,
morning.
yeah, I want to speak on why you said the question you said why international law is part of our sources of law. So I would like to start like as human beings, like no man is an island, and you also need some other, because we as a nation we have to engage with some other nations, and also we have like partners, like my other colleague said, some countries have allies. So the international law is used to help us to regulate our relationship with other nations as a subcontinent or subgroup continent nation, or in the face of the international level.
Right. That's okay. Thank you very much. Any other submission? All right. I agree with you. I only expected that maybe Adewale or Prince was going to change his mind when I said, why should Nigeria need to have international law as a source of Nigeria, as a source of law, especially since Nigeria is a sovereign nation. And I'm glad that he was able to stand his ground, at least to explain, and which was also backed up by the submission given by Joy. All right, very correct argument and presentation there. So now let's look at it as one of the sources of Nigerian law. Now, one thing we need to know as a foundation to this topic is that Nigeria is one of the nations of the world. And as a nation, and like Joy rightly submitted, no one is an island. So, Nigeria as a sovereign nation will definitely, at one point or the other, have relationship with other countries. And this relationship may be in relation to commerce or economics, political issues, and other areas of interest. So because of that, Nigeria as a nation is a member of several organizations. For example, the United Nations, African Union, Commonwealth of Nations, and so on and so forth. And because of that, and because of this membership or interaction or relationship, the country as a sovereign nation, by operation of custom at the international level, is duty bound to sign agreement with these different organizations. Of course, when you are joining an organization, you want to look at the terms and conditions that governs that relationship. Therefore, Nigeria becomes signatory to various international treaties or international documents or international accords, as the case may be. So therefore, international law or those treaties which Nigeria as a sovereign nation has signed up on automatically becomes part of what will influence our interaction, or part of what will influence our entire legal framework. Meaning that, oh, because Nigeria is a part of United Nations, decisions reached by the United Nations is somehow taken into our own system, and then they are applied to our day-to-day activities. And there is what we call customary international law. I think it was in this class that I made submission regarding when Boko Haram held sway in a certain part of this country and began to kill innocent individuals, that international community, the United Nations, had to, show concern and expected the government of this country to do more to save or preserve the lives of citizens of Nigeria and everyone that finds himself within the jurisdiction of Nigeria. Meaning that there was this expectation on the part of the Nigeria government to secure the lives and property of every Nigerian and those legally living within the country. So, issues of human rights became the foundation upon which the United Nations could speak to the government of the Federation. So, and it is customary at the international level that human rights is taken seriously. If the international community will not be interested in your country, at least they are interested in how the rights or how the citizens of your country enjoy the right that has been given to them, especially those rights that we refer to as fundamental human rights, rights that are inalienable, that you cannot take away from any man, rights that were not even given by government in the first place. For example, right to life, and then, other rights that falls within that category. Everyone all over the world have their right to life. and no one can take the life of another. No government can take the life of a citizen except through the operation of law. That is, maybe the individual has been convicted by a court of law, having been found guilty of a crime that death is the necessary consequence. It is at that point in time that government can exercise its power to carry out the termination of such an individual's life. But generally speaking, no government has the capacity or the right to kill a citizen or to encourage a citizen to kill the other. So the international community will most at all times be interested in how the rights of citizens can be protected. So that is an aspect of it, our customary international law. And also part of what is generally referred to as principles of international jurisprudence have also influenced the Nigeria legal framework. Sometimes international practices may find their way into our lives, to ensure that, for example, human rights is absolutely preserved. So, by virtue of all of these, the Nigerian legal system, being a mixed system derived from common law, customary law, Islamic law, and parts of international law, you see that indeed the Nigerian legal system cannot just boast of a single source of law, of our law. Consequently, there will be need to refer to international law as one of the sources of Nigerian law. But for international conventions or treaties to have its way into the laws or into our laws. Now, I think I need to say this so that it can further enhance our understanding. Now, when we talk about Nigerian laws include all of the sources that we have been talking about. And if there is a part of our Nigerian legislation that does not make provision for a certain aspect, we discover that either international law that we have subscribed to can cater for such. And therefore, we say that all of those laws, they are the bodies of the law that Nigeria can boast of. So, what we are also saying also is that for any of those international law, conventions, treaties that we think are part of our system, for them to be applicable in Nigeria, they are expected to be domesticated or ratified by the National Assembly. Mind you, this process of domestication is simply a way of formally and legally bringing such law to become operative within the Nigerian society. So we can either use the word domesticated, that is to be made part of our laws, or ratified, which ultimately means the same thing. So And if the National Assembly may have to do this, we will have recourse to Section 12 sub 1 of the Constitution of the Federal Republic of Nigeria. And this alone speaks of the constitutional basics for international law in Nigeria. I'll read from the Constitution of the Federal Republic of Nigeria, Section 12, sub 1. It provides that no treaty between Nigeria and any other country has the force of law unless it is enacted into law by the National Assembly. Okay? So, this established the dualist approach, meaning that the international treaties do not automatically become part of Nigerian law unless they have been formally ratified or domesticated or accepted or incorporated into our corpus of laws or into our bodies of law. So that provision is crucial to the operation of international law in Nigeria. Then, when you look at Section 19 of the Constitution, it also provides for the foreign policy objectives of Nigeria, which part of which is that the foreign policy of this country have respect for international law and treaty obligations, meaning that the Constitution, as provided in Section 19, says that Nigeria, as a sovereign nation, will at all times respect every international treaties or accord which it is a signatory to. Therefore, that's indeed make such law, that is international law, to be an integral part of the Nigeria legal system. So, under international law, a treaty is defined as any legally binding agreement between states. Because you must have heard that I use the word treaty, use the word accord, use the word convention. All of them can be interchangeably used, for one another. So a treaty is any legally binding agreement between states. And a treaty is a binding agreement between states that forms the basis for international law. By virtue of your acceptance to be part of the treaty, either by signing, automatically that particular international law is therefore binding on the parties, that is the states that have become signatory to the particular law. Mind you, I said earlier, and I repeat again, that a treaty can also be called a convention, protocol, or a pact as in P-A-C-T. It can also be referred to as an accord. So for other people who are listening to these lectures, apart from the 200 level law students, in your exams, you may be asked to identify other names that a convention can be called. So it can mean protocol, it can mean a pact, it can mean an accord. So, but what all of this stand for is that it is the content of the agreement that is important and not the name. So generally speaking, it is the content, the subject matter, the focus that is important and not the name that is so called. So therefore, any agreement signed between two or more countries is an international agreement. And then once entered into, each party has the duty to abide by the terms of that contract. And if any country chooses not to agree or to carry out the contents of such agreement, the nation or the country may be committing a breach, and then it may attract some form of sanction to it. Now, earlier on, I made reference to examples of international treaties that Nigeria is a signatory to. I'm going to point out two major of those as example to guide this class. The first one is the African Charter on Human and People's Rights. The African Charter on Human and People's Rights. This particular legal instrument has been domesticated into our system as African Charter on Human and People's Rights Ratification and Enforcement Act. That is the way it is referred to in our system. I'll repeat that again, that the African Charter on Human and People's Rights, after it was domesticated into our system, is now known as the African Charter on Human and People's Rights. Then you now put in bracket ratification and enforcement. Then it closes, and act is also placed at the beginning. So it is known in Nigeria as African Charter on Human and People's Rights, Ratification and Enforcement Act. That is how the name turned out to be upon domestication of the charter by the National Assembly, which is the recognized body saddled with the statutory duties to domesticate or ratify any foreign legal instrument. Another example of this law or international law that is holding sway in our legal system is the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. I'll repeat that again for the purpose of those who are taking note. I said the Convention on the Elimination of All Forms of Discrimination Against Women, with the acronym CEDAW, CEDAW, and that has been signed but not fully domesticated within our system. But of course, its terms may be applied or used as a reference to enforce women rights because of the fact that there are, the legal instruments that may want to discriminate against the Nigerian woman. So by virtue of this law, that can be protected. So as part of this, yes, Adeneko, you have
Yes,
a
sir. Can you say it again? The Convention of
the Convention on the Elimination of all forms of discrimination against women. You are probably interested in it because it relates to women. All right, so let's move on. Now, another thing we need to point out under this topic, that is international law as a source of Nigerian law, is customary international law. Before I said that Nigeria as a system has a mixture of customary law, common law, Islamic law, and some other customary international practices. Now, I just quickly want to touch on that so that you can have a broader view of the subject that we are discussing. So let me talk briefly on customary international law. Now, customary international law consists of general practices accepted as law, and this can influence Nigerian courts, especially in the areas of human rights and diplomatic relations. Okay, so I repeat again that customary international law consists of general practices that are accepted as law at the international level. And that was why I said that issues of human rights does not pertain to Nigeria alone. It's a matter of international standard because of the fact that your government may deny you of good roads, good public water, security, or other social amenities. But there are some rights that the government of your nation did not give you that they cannot take away, or that they should not toy with, or that they should shy away from defending. And that's why I talked about issues of right to life. And that's why the Nigerian courts have, in some cases, recognized customary international principles, especially where they are, in conflict with our Nigeria or domestic laws. Meaning that if anyone is trying to enforce some form of rights or some form of international practices that offends our local law, our laws or our courts are saddled with the responsibility not to recognize them, or to recognize them and see them as parts of practices that may offend our domestic law. So, therefore, even though customary international law are international general practices that have become law, yet they also are expected to respect the local enactments. Also, another area we can look at it from is the issue relating to decisions reached by international courts. What effect do they have on Nigerian system as a source of law? And what we need to know is that the Nigerian courts occasionally refer to international law in interpreting domestic statutes, especially in order to be able to give life to domestic status or laws. Our judicial system sometimes look at what is obtainable at the international level to see how our laws can be better for it. And this mainly is on issues pertaining to human rights and also constitutional law. I refer you to the case of Abacha and Gani Fairimi, reported in year 2006, Nigerian Weekly Law Report, part 660 at page 228. I'll repeat that again. I'm making reference to the fact that those international law can sometimes be referred to by Nigerian courts with the view of making our Nigerian law to be better off. And that's why we are making reference to the case of General Sani Abacha versus Gani Fairimi, reported in year 2006, Nigeria Weekly Law Report, part 660 at page 228. Mind you, for those who may not know what we mean by reported in year 2006 Nigeria Weekly Law Report, that is what we call citation of cases. Citation of cases. Now that I've given you that the case was reported in 2006 Nigeria Weekly Law Report, if you pick any Nigerian law report, Nigeria Weekly Law Report is a book which is just for law reporting, and you pick the series 6, part 660. That's the way they are arranged and labeled. Okay, so that's just the citation of the case. Why are we talking about this case? Now we want to look at what the Supreme Court said in relation to the points that we are trying to make. The Supreme Court held that an international treaty, even when ratified, must be domesticated to have binding force in Nigeria. But the court went further to say, however, courts may rely on international principles to guide their reasoning. So, if you read the case of Abacha and Gani Fairimi, you will see issue of human rights in play, and how the Nigeria court, through its wisdom, were able to affirm or protect the rights of Gani Fairimi or issues relating to fundamental human rights. They now looked at international law, international treaties, international practices to say it is important that the rights of every citizen must be protected against even the authority of the nation. And that's why I said earlier that even the government cannot order the death of a citizen except if the citizen has gone contrary to law. It is not that the government does not have the capacity. The government can give the directive, the capacity is there. But the power to carry it out, to do it, is lacking, especially when the citizen has not committed any form of crime to warrant his fundamental human right to be taken away from him. So that is an aspect of the subject that we are looking at. Also, another aspect of this topic, international law as a source of Nigerian law, is that sometimes, for example, like the United Nations, they can issue what we call soft law or international best practices. They issue it in form of resolution. So it's possible you must have had United States resolution on this and that. So meaning that the United Nations from time to time provides resolution to guide, the way nations deal on some issues. Also, international law can provide guidelines, even though these resolutions or guidelines may not be binding, but they can influence Nigerian policies, or they can even aid the development of our jurisprudence. They can aid the development of our laws, even though they are not binding. If you recall, when we're talking about ratio decidendi, we spoke about the fact that there are some precedent, judicial precedent, that are of binding authority, while some are of persuasive authority, if you can recall. So what we are saying is that sometimes there can be international resolution or maybe United Nations resolution guideline on some aspects of our life as a people, even though such principles or such guidelines or resolution are not binding, but they influence our policies. I give you an example. Nigeria as a nation aligns with international standard on anti-corruption. It aligns with international standard on environmental law. When we talk about climate change, what a nation must do to protect the environment, to ensure that the environment is not put in danger, the kind of activities that are allowed, whether bush burning will hate good life, or maybe indiscriminate dumping of refuse and all of that. There are some international guidelines that are being provided like rules, even though they are not binding. They help to shape our system. And that's why, even though corruption is already something very popular within our system, the government, through its various organs, still think that they should fight it, even though sometimes we have reasons to believe that the fight is just done by words of mouth without necessary action. Sometimes we even say there is selective fights. I saw something online yesterday. A certain politician said for the past years, more than a decade, that he has been facing criminal charges relating to corruption, and that today now he has been freed by the court, that, oh man, your sins are forgiven, or you didn't commit any of these alleged crime. So therefore, go and enjoy your life. And then I read the comments underneath the post, and someone said, you have joined them. The reward for joining them is that your sins are forgiven through the court. That's what the person wrote. Of course, few of us may understand the position of that individual. That in this country, we are not indeed fighting corruption as people that are serious. If you have been alleged to have committed an offense, all you need to do is to join a particular political party, and then you automatically become a saint. This is despite the fact that Nigeria, both at home and abroad, professes to be engaged, fully engaged in the fight against corruption. But the point we are making is that international law provides guidelines on all these aspects. But whether or not it's binding is the issue here. But we are saying they are not binding, but they provide guidelines on how we live our life. They provide guidelines on how our policies can be positively influenced. If Nigeria is indeed serious with fighting corruption, what it means, therefore, is that those international guidelines on anti-corruption, Nigeria will hold to it firmly. Nigeria will hold to it firmly, and they practice it to the last. But what do we see? A man is alleged to have committed a crime. If it's here in Nigeria, before you know it, either the case file is missing, or they will kill the case with different things. They can transfer the judge. Sometimes they can even change the location of city, do a lot of things. But if this same individual is arrested outside the shores of Nigeria, they can be adequately prosecuted. We have seen cases like that here in Nigeria, where a man was tried here, and then he was seen not to have committed the alleged offenses. But when he got outside the country, he was arrested on similar charges. He was prosecuted and found guilty, and even served the term there. And when he returned to the country, again, the same people also rolled out the drums to celebrate him, to welcome him back home. So that is to show to us that we as a people, we are not in any way fighting corruption, even though there are guidelines for us to do so. So, therefore, these are the various ways in which international law affects our legal system. So, in conclusion, we submit that international law plays a very important role in shaping our laws. through treaties, through customary international law, through judicial references, or through guidelines or resolutions reached by international community. But what is key is that before they can shape our jurisprudence, they are expected to be domesticated before they can have the force of law in Nigeria. And then, once they are domesticated, they have the force of law as if such laws were ab initio made by the National Assembly, the arm of government that has a duty to make law for Nigeria. So that is our lecture on international law as a source of Nigerian law. I'd like to take questions before I'll take the last source of law that we have in our course outline. Any question?
Good morning. Good afternoon, sir.
Good afternoon.
Sir, please, international customary laws, do they also have the requirement of domestication attached to them?
Yeah, those practices can also be incorporated into our system, maybe through a process of lawmaking. Okay? Was I able to answer your question?
Yeah, but are they enforceable even without domestication?
No, they are not, but they can influence the way our policies are drawn. Then if they come to bear at the court of law can also be persuaded by such practices to arrive at a judgment that may serve the end of justice. Okay? Yes, Olamingoke.
Good morning, sir.
Good morning.
Good afternoon, sorry. I want to ask, after
Yes.
international laws have been domesticated, can they be repealed? And if they can be repealed, how?
If any law can be repealed, it goes through the National Assembly that is saddled with the responsibility to do so. All they need to do is to engage the legislative procedure, and then they carry out the actual repealing of that law. Okay? Any other question?
Okay, sir. Thank you, sir.
All right. So let's take the last source of Nigerian law that we identify is known as opinion of jurist and legal writer. Just like I asked when we started the topic international law, how are the opinions of jurists and legal writers seen as source of Nigerian legal system or sources of law in Nigeria? As a matter of fact, that can be a good question for you in your exams. Anybody wants to give us an answer? Anyone?
Sir, please, can you repeat the question?
I said, how do we how can we relate to opinion of jurist and legal writer as a source of Nigerian law? Nobody? All right, let's go into the lecture. So eventually, if you find it somewhere and it becomes a question to you, you may have to try out the law. Now, the views of jurists. Jurists are judges. The views of judges and legal writers serves as a persuasive source of Nigerian law. Yet, they are not binding, like legislation or judicial precedent, but they can influence judicial and legal development. Now, let me give you an example. Please, can you mute your mic? Now, let me give you some examples. In this faculty, Faculty of Law, University of Lagos, we have erudite scholars that have made names for themselves by virtue of the knowledge they have acquired over time in their various areas of practice. And in every part of this country and even around the world, they are respected for their contribution to legal development. I give you an example of the learned SAN, Professor I.O. Smith, who is a professor of land law, property, and all of that. I recall that about maybe sometimes around, let's say about 13 years ago or 15 years ago, I had cause to travel all the way from Delta State to Lagos State to come and buy one of his textbooks because of the fact that he is an authority on that aspect of law, land law. So, when sound decisions are to be given in court, the legal work of these scholars constitutes part of what they look at. When you look at the likes of Professor Ben Akabweze on constitutional law, or the likes of the submissions of Professor Akin Oyebode on international law and jurisprudence, even when you look at the works of A.O. Sonny on taxation, name them. These are renowned scholars who have shared views on various aspects. And these views have constituted reasons for many decisions. So, therefore, their views, their opinions, and in one way or the other, form part of the laws that we have as a people. Talk of the likes of Professor Mika Chianu, when talking about land law, these are renowned scholars that most of laws that we have on land law and all these areas have their inputs, or their input were given by students that they taught. Haven't considered such views as salient and practical enough to form part of the guiding rules and laws of the Nigerian legal system. So they have influenced, even though we can say they can influence judicial outcomes, they have influenced judicial outcome in several ways. So basically speaking, when we're talking about opinion of jurists and legal writers, we're talking about writings, commentary, and analysis of scholars, legal scholars, and academics, or even experts in law. And where do you find the opinion of jurists? Where do you find the opinion of legal writers? You find them in journals, in textbooks, in articles, and so on and so forth. And what is their role in the Nigerian legal system? One, they serve as persuasive authority. That is, the court of law in Nigeria may, I use the word may, refer to their work to clarify complex legal issues or principles, particularly in areas where our laws are not sufficient enough to cover. That's one. So they serve as persuasive authority. Number two, they assist in interpretation of law. So sometimes judges and legal practitioners oftentimes rely on the academic writing to interpret legal provisions. That is one role they play. Number three role is that they aid in legal development. They aid in legal writing, evolution of legal thoughts, reforms, and they propose improvements on how things can be done better. I was sharing with you, I made reference to the learned essay Professor Abiola Soni on taxation. Recently, when the federal government of this country wanted to form the Tax Advisory Board, he was selected. As a matter of fact, as we speak, he's still a member of that body, meaning that his contribution to taxation has become something of reference that will aid the development of taxation in Nigeria. And then this view that have been invested from him consequently may sometimes be included in laws that are made on taxation. And then what do we have? We simply have a country that is developing legally. So that is another role that opinion of jurists play in our legal system. Then lastly, they also aid or influence judicial decision. I've explained that excessively, in this class. And mind you, I've given examples of learned scholars in this aspect. When you talk about contract, law of contract in Nigeria, and even constitutional law again, like I said, you refer to the likes of Professor Ben Nwabueze, not Akabueze, Nwabueze. We talk about renowned professors like Professor Iche Sage. If you train in Nigeria in maybe the last 3 decades, you must have read, the individual must have read Sage Law of Contracts. Then we have the likes of Professor Ayo Ajomo. They have all influenced our constitutional and administrative law. So these are renowned individuals that have one way or the other affected, our legal jurisprudence. What about internationally? When you talk about international scholars, you refer to the likes of Roscoe Pan. You refer to the likes of HLA Arts. You refer to the likes of John Austin, the same John Austin that we deployed one of the definition of law that he gave in this class. These individuals are renowned scholars of their own that they have influenced our system. So, but like we said, their submissions or contributions are not binding. And because they are not binding, they are of persuasive effect, meaning that the court can rely on it or can choose not to rely on it. But in all, opinion of jurists and legal writers do not have the force of law. They remain important persuasive instruments in the Nigerian legal system. That is to say that, yes, they are important, but they don't constitute laws, so that you don't mix it up with actual laws. But what we are saying is that one way or the other, all of these aid in arriving at laws that may be enacted by the body that is saddled with the responsibility to make laws. Now, do we have any question on this before we call it a day? Any question? So with that, we'll have come to the end of topic 3, which is the sources of Nigerian law. And by the time we meet next time, we'll begin by interpretation. Begin with interpretation of statute. That is topic 4. And we are gradually coming to the end of the course. Yes? Any question? Okay, so in the absence of any question, we call it a day here.
Sir, please, I have a question.
Yes.
Sir, please, is it the citizens that write a letter to these international organizations like the United Nations, or and how many days? Because, for example, that time that it was during NSAS, they said they wanted to protest for like 100 days, so the United Nations would would come to it, but they didn't make it happen. And or like, how many days will it take the citizens to do something like that? And is it true that the United Nations would intervene?
Well, we can't talk of days. We can't. It all depends on the severity of what is happening in that particular country. Mind you, every country is a sovereign nation. So the United Nations cannot just intervene or interfere, except where there are obvious cases of even the government being part of the violation of the rights of the citizens. So it may even, but what those kind of protests, what they do is that they create international awareness, and when, in the era that we are of the social media, if anything is happening in a country that is somehow awkward, before you blink an eye, the whole world is aware. So it makes nations to show interest. So, okay, what is happening? What can the United Nations do? And so on and so forth. Okay, but there are no specified days that some things must happen before action can be taken. Okay, was I able to
Okay,
answer?
sir. Thank you, sir. Yes, sir. Thanks so
Thank
much.
you very much. So we call it a day here. Please enjoy the rest of your day. Good afternoon.
So are we to write attendance?
Attendance, sir. Attendance, sir.
Yes, my attendance is already with me. Don't bother.
Okay, thank you, sir.
Thank you, sir.
Thank you, sir.
Yeah, whatever.
Thank you, sir.
God damn.
Sorry, please. Are we not writing attendance? I beg.
You said there's no need.
He said no.